Students, today we can solve one more problem with regard to the Mohammedan law on the aspect of the option of puberty. Option of puberty. So, I have selected one problem from the previous question paper with regard to the aspect of option of puberty. So, probably you know what is meant by puberty. Here the what is meant by puberty under Islamic law, that here the with regard to the puberty, the age will be calculated whether boy or girl, whether they have attained the age of puberty or not, for the purpose of contract of the marriage. That means even though the boy or girl, they will not attain the age of puberty, they can get married. They can get married even though they don't have the capacity to get contract, get involved in the contract of marriage. And as you know that as per the essentials of the valid marriage, there are four conditions are there. First one is the parties to the marriage, that is husband and wife, must be a competent. So what sort of the competence means? They should not be of unsound mind, likewise. So they should not suffer from insanity, likewise. Here, with regard to this parties to the marriage, they must be competent means if they don't attain the age of the puberty, here we cannot say majority. Here we have to say the age of puberty. So even in this case, they are deemed that they are competent to marry. That is, so here with regard to the if they are sound mind, it is okay. If only three questions, three aspects, if they met with regard to the marriage, then it is more than sufficient. Suppose the parties to the marriage, they are of sound mind. They belong to the Islam religion. And even though they have not attained the age of puberty also, they believe to be, they are competent to get married. So here that is the first aspect. So the second one is the consent of the parties. That is, if they have attained the age of puberty, their consent will be taken. Otherwise, their guardians' consent will be taken. Otherwise, the guardians of the bride and bridegroom will be taken into consideration for the purpose of the marriage. And the third aspect is the required formalities has to be duly completed. That means according to the Islamic tradition, whether it is a Shia, Sunni, likewise with regard to the getting the witnesses and all those things. Last one is there must not be any prohibition or impediment in contracting the marriage. That means they should not be under the age of prohibited degrees of relationship. So these are all the essentials of the valid marriage. But the only thing we have to concentrate with regard to the age of puberty. Here, what has been seen under the Islamic law with regard to the age of puberty? Age of puberty is an age at which a person is supposed to acquire the sexual competency. So that is the what you call understanding with regard to the what is meant by age of puberty according to Islamic principles. Age of puberty is an age at which a person is supposed to acquire the sexual competency. So this has been well said in the case of Atika Begum versus Muhammad Ibrahim. Here it has been said that according to Mohammedan law, a girl becomes major on the happening of either of the two events. One is that the completion of her 15th year or her attainment of a state of puberty at a certain period. So this is the thing we have to see with regard to the age of puberty. Here today we are going to look into the one aspect with regard to the age of puberty. As you know that even though the bride and bridegroom, they have not attained the age of puberty, they can get married. So here now this is not possible because of the Child Marriage Restraint Act of 1929. But according to the practices, they can get married even though they have not attained the age of puberty. Here with regard to the problem solving, I need not have to tell the steps. Here we are following the steps of FIRSC, that is fact, issue, rule, analysis, conclusion. That means if we solve the problem, it may be any subject, then it will the valuer can comfortably give the marks. So we have to simplify the facts. We have to write the issue. What is the issue which is exist in the problem, and we have to go for the provision of law, that is rule of law. Then we have to analyze it. Then we have to give our conclusion. So these are all the steps under which we have to solve the problem. Here, with regard to the well, let us go with regard to the problem. It is a problem with regard to the option of puberty. Here, a Muslim father performs the marriage of his daughter before she attains the age of puberty. So we have discussed with regard to what is meant by age of puberty. We have discussed here. The girl intends to revoke the marriage after attaining the age of puberty. Can she do so? That is the problem. Here, the problem has been given like this. A Muslim father performs the marriage of his daughter before she attains the age of puberty. That is when she is under the age of puberty only. A Muslim father, he has performed the marriage of his daughter because it is permitted under Islamic law. That is it is a valid marriage. So here, when the girl attains the puberty, here we cannot say the majority. The girl intends to revoke the marriage after attaining the age of puberty. Can she do so? Here, what is the age of puberty? Is 15 years. But according to the Hidayah, that is the one of the roots of the Islamic principles. Here, the earliest possible age of puberty was with respect to boys 12 years and with respect to girl is 9 years. But this cannot be treated as the absolute rule regarding the age of marriage, because keeping in view with regard to the sexual competency. Here, whatever it may be, here we can fix our mind with regard to what is meant by age of puberty. Means it is the age of 15 years. So otherwise we can say that the person is supposed to acquire the sexual competency. Here, for our purpose, we can fix that the age of puberty is a age of 15 years. So here we have to simplify this problem under this way. Here, a Muslim father marries his daughter when she was under the age of puberty. So that in this way we have to simplify the problem. A Muslim father marries his daughter, and when she was under the age of puberty. So this is the problem. In this way we have to simplify the problem. And when the bride or is the daughter, she attains the age of puberty, she wants to rescind the marriage, whether she can rescind or dissolve the marriage. So this is the aspect we have to see here with regard to this problem. So she has got married. That is, it is very simple. She has got married when she was not attained the age of puberty. Whether she can rescind the marriage when she attains the age of the puberty. Here the issue is that whether a minor girl can rescind the marriage when she attains the age of puberty. That means what is minor? Who is a minor? That means we can see where the girl who has not attained the age of puberty can be called as a minor girl. Okay, we can say that whether a girl who has not attained the age of puberty, we can call whether a girl at the time of the marriage, has not attain the age of puberty can rescind the marriage when she attains the age of puberty. So this is the issue. Very simple issue. So here we have to frame any number of issues. Here it may be as far as possible you frame the issue in a very short manner. So here issue is that whether a girl at the time of marriage has not attained the age of majority can rescind her marriage when she attains the age of puberty. That is, here we are discussing only with regard to the puberty. Here there is no aspect we have to see with regard to the majority or minority. Here under Islamic law, only puberty aspect will be taken into account. Here the issue is that a girl who has married when she was under the age of puberty, when she attains the age of puberty, can she rescind the marriage, whether she can dissolve the marriage? So that is the problem which has been given here. Which is the provision of law which is applicable here is section 2 clause 7 of the Dissolution of Muslim Marriage Act of 1939 is applicable here. And the case laws with regard to this aspect of puberty is Atika Begum versus Muhammad Ibrahim and Aziz Banu versus Muhammad Ibrahim. Just now I have told you what has been discussed under the Atika Begum versus Muhammad Ibrahim. Privy Council has beautifully said that with regard to the age of puberty, with regard to the girl, that is Mohammedan, according to Mohammedan law, a girl becomes major on the happening of either of the two events, the completion of her 15th year or on her attainment of a state of puberty at an earlier period. So that is with regard to the Atika Begum versus Muhammad Ibrahim. And with regard to the Aziz Banu versus Muhammad Ibrahim, the aspect is that only in the exceptional circumstances, by a person who can, that means who is under the age of puberty can be called as a minor. So when he attains the age of puberty, whether he can rescind the contract means only under exceptional circumstances. That means under exceptional circumstances, when his marriage or her marriage has been conducted by his father or grandfather fraudulently or negligently. So under those circumstances, a minor has got a right to repudiate the marriage on attaining the puberty. This aspect has been discussed under the Aziz Banu versus Muhammad Ibrahim. Except these elements, that means when the marriage would not have conducted fraudulently or negligently, the minor doesn't have any right to repudiate or rescind the marriage. So this is the provision of law with regard to the option of puberty. So here we have to analyze these facts, issue, provision of law with regard to the problem with regard to the option of puberty. Here what should be the analysis with regard to this problem is, before 1939, a Muslim wife is not entitled to exercise the option of puberty if the marriage was contracted by her father or grandfather. So here it is as if the parties are competent to contract. That means even though the bride who is under the age of the puberty, we can say that a minor according to Islamic law. So whereby the marriage has been contracted by the guardians of the bride and bridegroom. That means they are on behalf of the bride and bridegroom, they will contract the marriage. So in the sense that they have attained the age of majority, so that they can contract the marriage on behalf of the bride and bridegroom. So that's why this will be held as the valid marriage. So here before the 1939, that is the Dissolution of Muslim Marriage Act of 1939, a Muslim wife does not have any right to choose for the option of puberty. That means she cannot dissolve her marriage. So that was the law. But now, after the dissolution of Muslim Marriage Act of 1939, which has modified the earlier law. Now she can go for the divorce when her marriage has been conducted under the age of puberty, and yeah, this option she can exercise till she attains the age of 18 years. So under the old law, the option of puberty by wife was to be exercised by her immediately after immediately. That means with regard to the not Islamic law, with regard to the any other things, any other law. Now the act provides that wife can exercise this right up to the age of 18 years, provided the marriage is not consummated earlier. So this is under the old law, option of puberty was not available where the minor marriage was contracted by father or father's father. But now a wife may exercise this right even if she was given in marriage by her father or father's father. Now this under this act, which provides the relief for a wife, she can exercise this right up to the age of 18 years, provided the marriage is not consummated earlier. So that is the thing we can see with regard to the present law. And she can go for the divorce. That means she can her marriage has been conducted at the age of under the age of puberty. She can go for divorce as per section 2 subclass 7. So this is the aspect of what we can see with regard to the option of puberty.